qualified as an expert. Mr. Weinstein, you didn't find her qualified yesterday? The court, no. She'll go through the same establishment of the issue. Were you here yesterday? No, you were not. You weren't. Okay, so here's the way it goes. The state is going to qualify her. There's no requirement for there to be a pre-admit hearing for that. Your colleagues attempted to ask me to do that yesterday. I was not of the opinion to do that. Mr. Weinstein, would the court be willing to qualify this expert prior to the jury coming into the courtroom? The court, no. Mr. Weinstein, that's the way in my experience it is. The court, no. Mr. Weinstein, always been done in federal court. The court, it can be done. There are some 11th Circuit cases I was shown yesterday that authorize for that. So, Mr. Weinstein, I understand that you may be authorized to do that. I was suggesting that the better practice may be to do that before the jury is present. The court, Mr. Steele asked me that yesterday. Mr. Weinstein, thank you, Your Honor. The court, I am going to see if they qualify the witness using the Daubert standards and 702, and we'll let you all voir dire the witness accordingly. And then I will make a decision as to whether or not a particular individual is able to testify in that manner. Mr. Steele, Your Honor, can I just get a continuing objection? The court, yes. Mr. Steele, I believe the case, the 11th Circuit case is where. The court, you're right, it is where. Thank you. Where I don't believe it says that in front of the jury. And if it wasn't done at all, you have a discussion to find someone. No, it wasn't, but there was no pre-admission. It was done in front of the jury because of the type of case it was. I think it was a firearms or ballistic or whatever else. And Mr. Steele, I think the court just made that finding anyway. I'm objecting to it in front of the jury. I'm objecting not to having a Daubert hearing outside the presence of the jury. So, state laid the foundation for Detective Dennis to testify as an expert. The court also read the admonition as to an expert and fact witness before this witness testified. I gave all of you the opportunity to voir dire the witness before the court made a determination of whether or not she would be tendered and qualified as an expert. None of you took the court up on that because up to that point in time, I had not ruled that she could be qualified as an expert. So, Mr. Steele, I'm in possession of your motion. I don't believe it's timely. I believe it's waiver. I believe you still have the opportunity to cross-examine Detective Gaither about anything that she may have in terms of her investigation of this case. So for that reason, I'm going to deny the motion at this point in time. You may have two.
Your Honor, I believe that the court is misunderstanding the sequence in paragraph 5 of my motion to strike Detective Gaither's testimony. The sequence is as follows. The court, outside the presence of the jury, I believe the night before, maybe earlier that day, I don't remember, did exactly what you just read, and denied outside the presence of the jury, Daubert hearing.
I did.
Then what happened is...
And that was because we're allowed, or in the court's estimation, even though we may disagree, I believe that gang expert testimony and this particular witness's background would lead her to be qualified. But the state still had to do that in front of the jury for me to make an expert determination.
So my understanding of where I understood it is different. The court made that determination without the hearing, and then
which I didn't need to do, and you all disagreed. I get it.
So anyway, the way then sequentially, this honorable court, as Detective Gaither was about to testify, gave that instruction, which you gave 2 times previously, about Detective Belknap, saying that this is a dual witness. I don't have to repeat it. I presume you know what I'm talking about.
Yes, sir.
Witness, expert witness. When you did that, and then the state is qualifying Detective Gaither, I, Brian Steele, stand by. I'm not accusing this court, and I'm certainly candid, always got over with the court, but I took that as...
No, but that wasn't. You had the right to voir dire the witness before before the state proffered her or accepted, the court said she was an expert. You had the opportunity to fully examine her, because you know what would have happened if they would not have qualified this witness pursuant to Daubert and 702. I would have excluded her. You would have probably moved to have her excluded as a witness, an expert witness, which I would have granted. But that didn't happen. And I asked all of you whether or not you wanted to take advantage of that. So
what I'm trying to say,
you waived that issue at that point.
What I'm trying to say is to ask the questions in front of the jury, the probing questions that this honorable court has allowed on every other Daubert witness.
Well, why didn't you do it? I mean, because you could have done that, and that was the danger for the state asking me to do that at that point. Because had they not gone ahead and qualified that witness, they would have fallen flat in front of this jury, not having a witness that was qualified.
Well, I would have fallen flat in front of the jury because I would.
But you had that right, sir.
I'm just trying to get out my statements. The questions I would have asked are occurring in front of a jury. We would have asked her the basis of knowledge. Where is the gang book that we don't have, that she's relied upon, that Detective Belknap relied upon, that we can't, for whatever reason, I don't know.
I think nobody's actually brought a gang book as of yet.
Well, you told me, I asked for it, you told me.
If they have it, they need to tender it, yes.
I have nothing. I would have asked the questions specifically about Mr. Williams and how you separate, just like I did with Detective Belknap. How do you separate a law?
Aren't you going to cross her on as to that?
No, I'm not going to cross her. I already did it with Detective Belknap. I don't have to repeat. So my point is, there was absolute candor always with the court. I did take it as a fait accompli because I don't know why.
No, but that's not true, sir. And that's a misstatement and a mischaracterization. You're telling me that I've already made up my mind at that point in time. It was all but a certain conclusion. It was not, sir. That's not the way that this court looks at its role as the gatekeeper and its role as a referee.
Well, I understand that you're offended.
I am offended because it's not true in terms of what you were given.
Well, I'm going to tell you I'm offended because no other time in this trial have you given a instruction to the jury before you found somebody expert to say this person's going to give expert and lay testimony. So as a listener, it was already a fait accompli because you already instructed the jury that that witness was going to provide expert and lay testimony.
Did you object at that point in time?
Your Honor, I believe.
Did you object at that point in time?
I believe you already.
Did you object at that point in time, sir? I'm asking you a question. Did you object to at that point in time saying, Judge, she hasn't been qualified as an expert as of yet? I don't think you should read that instruction as of yet.
It would have been frivolous to say.
But you didn't object, though, did you?
Listen, I'm not playing.
I know I'm not. I'm asking you. Look,
I'm just saying. To me, there's nothing but candor in my motion, always with the court. I love this court. I'm not attacking you. I'm telling you how it appeared to a reasonable person.
Sure, but that's not true. That was not true in terms of the way and the what you have been given in this case. The court made a ruling. Like I said, I rule the way I see it. I mean, I have no interest in this case. In fact, I tell the jury that when I charge them. I don't.
Your Honor, I cannot find another case. The Daubert hearing was held in front of the jury. I cannot find it. So anyway, my motion.
Okay. All right, sir.
My motion goes much deeper. You just took one paragraph, which I stand by fully. But
and then
nothing here. I'm sorry.
Go ahead. I'm sorry. I apologize. Go ahead.
Nothing here. You know, I listened to the testimony of Detective Belknap. I looked at my notes. I had other people do the same. Look at their notes. I then checked it online because there's I know it's not official, but there's a video of this trial.
Yeah, it's daily.
I then looked at Detective Gaither's statements and testimony as my notes. I asked others, and I watched that online. Your Honor, there's no need for this witness to be an expert. All she's doing is corroborating and supporting her coworker. This is like a vouching improperly. This is like another summation, and it's coming from one of the case agents or lead detectives who is saying the exact same things. You've heard nothing. I challenge it. I put it in paragraph. I put in two different paragraphs. I put in paragraph 6